Hey y'all, how's it going? Um, this is a explanation of the December 14th, 2020 hearing. Um, I have to do this because people who've watched the videos, they need an explanation because they don't understand exactly what went on. They think that something happened, and then um, they don't understand that judges, courts, and attorneys and these prosecutors they can lie. So 90% of what you heard was lie, um, and then you don't really understand what happened. So um, that's what this is for. So here we go.
You are now joining the meeting. Afternoon, we'll get started here momentarily. Okay. One moment, okay? Okay, thank you. Thanks. While I'm getting this ready to go on the record, who's with me? Is that Miss Hadley? Kimberly Hadley, yes. Mr. Quintero? Please enter a conference ID.
Hello,
Hi, Mr. Quintero, are you there?
I am David Quintero in propria persona, present by special appearance.
Okay, well, we're not on the record yet, sir, but thank you for identifying yourself. If you're the meeting organizer, press star.
All right. So he said that we haven't started, right? But the first thing they want to do is they already want to establish that jurisdiction, right then and there. He's saying we haven't started yet, and and I never responded to their name, right? Their name, their all caps name, right? So there we go.
Okay, can everybody hear me? Can, yeah. Yes, yes. All right, excellent. Thank you, folks. We're on the record. This is in SP 2017-0042. It's in right in the state of Arizona through the Department of Economic Security and David Quintero petitioners and Kimberly Hadley respondent. This is a date and time set for order to appear reinforcement of child support. And let's have the record reflect that both parents are present and David.
First and foremost, he stated what we're here for, which is the court subject matter, right? Um, Stating that both parties are here, and and he wants to proceed with the case. Right now, court hasn't started officially, right? He's calling it is like basically it's like preparing a meal, and you don't sit down to eat yet. You're just speaking about the meal, so to speak. I don't know if that analogy works, but here we go.
Assistant Attorney General is present on behalf of the state. Let me have both Mr. Quintero and Ms.
Attorney General is present on behalf of the state, right? Not on behalf of the child, not on behalf of the mother, not on behalf of the state.
Raise your right hands. We'll have you both sworn in. Thank you. Do you and each of you solemnly swear that you'll speak the truth, the whole truth, and nothing but the truth, so help you God? Yes.
I'm not here for that matter. I'm actually waiting for a response for the documents I filed on the record.
Okay, Mr.
All right. They asked us to swear in, basically to participate in court, right? She participated because she doesn't know what's going on, but she wants what she wants, which is her money, even though it's not hers and she doesn't have a right to it. Because of Blessing versus Freestone, Sage versus Sage, Holmberg versus Holmberg. I'm sorry, Sage was the wrong one. U.S. versus Sage. Anyway, so I'm not swearing in. I'm not submitting to their jurisdiction right now. Court hasn't started. Okay.
Tim, you haven't answered the question though. Are you swearing to God or affirming that you'll tell the truth in these proceedings? Did you hear the oath that was just administered, sir?
I appreciate your questions, but I'm only here
so that we could either dismiss the matter with prejudice or you could write an order I can appeal. I'm here.
There you go. There you go. Let them know what I'm doing, what my status is, what procedurally needs to happen, and that I'm not interested in anything else.
Give persona by special appearance.
Excellent. Thank you, sir. Let's just have the record reflect that Mr. Quintero is not so sworn or affirmed, so he is therefore not considered to be under oath. Court will therefore consider that and developing its inferences in connection with any statements that he makes in connection with the proceedings today. Sir, just for your information, frankly, for the information of the parties generally, the court has ruled, the ruling was issued today, so it's in the court file. Sir, generally speaking, the one action that you filed that the court allowed and is considering in connection with today's proceeding was your motion to dismiss for lack of subject matter jurisdiction, which motion was denied. So you'll see the court's ruling.
And there's your due process violation. He did that sua sponte. Whoever brings the claim brings the jurisdiction. Jurisdiction has to be proven on the record. And at that moment, you just heard me win my case. From here on out, for the rest of my life or the whatever amount of time that this takes, my only purpose is to have it dismissed because the case is over at this point in time.
It's been filed, sir. Okay? So, and the court has addressed in that ruling all filings by Mr. Quintero. So the only matter that's pending today is the request to enforce support. And so we'll be going forward on that matter today, okay?
I do not agree. I do not consent. I am only here so we can motion to dismiss for lack of jurisdiction with prejudice, or you can write your order so I can appeal.
All right. So, right at the very end of what he said, okay, basically consent. You always have to rebut everything. And I told him exactly what I said. That's not what I'm here for.
The order is written, sir. I want you to understand that it's been written and it's filed, okay?
I do not understand. I'm not interested. I do not consent.
Fair enough. Thank you, sir. Okay.
You're welcome.
We'll proceed despite Mr. Quintero's lack of cooperation with the proceedings. And let me just ask, Mr. Ronald, do you have any questions for either Mr. Quintero or Ms. Hadley at this time?
Judge, this is actually the petition was filed by a mother in this case. So I can start, Judge, with some questions for Mr. Quintero.
Do you have any preliminary matters that you want the court to consider at this time?
Judge, there was in this case, states information that the last payment was made December 6, 2020, which was by unemployment, which has been coming in at $120 a week. And there's only been the one order in this case, which was issued July 31st, 2017.
Do you have an approximate number? Do you have an approximate amount of arrears?
Yes, Judge.
None of this here is important. It doesn't matter. There's no case. There's no jurisdiction. There's no case. So, it's like it's not even happening. The moment I start acknowledging this shit, I'm fucked. So I have nothing to say here. I have nothing to say, because what they're talking about has nothing to do with me.
Based on a calc report done November 2nd, 2020, it's a $8,876.60 and an interest amount of $1,845.63. And it's from the period of August 1st, 2017 through October 31st, 2020. I'm not sure that the mother has the exact same figures that the state has come up with in its calc report. So.
Got it. All right. So the approximate arrearages or principal and interest combined about $10,000. Is that what I heard? Is that right? All right. And when was the last time that Mr. Quintero made a voluntary payment?
I'm just looking at that, Judge.
He's never made a voluntary payment. I'm sorry.
Ma'am, I'm sorry. Just please don't interrupt. I only want one person to speak at a time. Thank you.
Of course.
That was the baby mama that opened her mouth and they told her to be quiet. You got how nobody's here for her? She's nothing more than the informant. She's the she gets the finder's fee for basically turning in a name to the agency, to the state. But other than that, she doesn't matter. She doesn't matter. She's only like she's a witness clothed, clothed witness basically to pretend that she matters. But she opened her mouth and they told her to be quiet. Because child support has nothing to do with the children or the families. Nobody is there for her. The state is there for their money.
Just checking real quick, Judge. So, Judge, it does appear that the first, there was a payment from an income withholding order. I'm not sure if the judge, if you're considering that voluntary or not, but there were, back in June of 2020, that's when the first income withholding order payment came in. And prior to that, there was a payment in May of 2020, a tax seizure. So other than that, there's been unemployment. There's 3 income withholding order payments and then unemployment. So, but it's all been since May of 2020. So, and the original order was in 2017.
All right. Thank you. Before I hear from either parent, do you have any questions? I know you're not the petitioning party, but would you like to ask any questions of Mr. Quintero?
Oh, the state judge?
Yes.
Yes, I have a couple.
He just said that he's not the petitioning party. Really? Because in the documents, the state is written under the where it says petitioner in the documents. So they can lie. They can lie and say whatever they want, right? These are all their little tactics.
Okay, you may proceed.
Mr. Quintero, can you hear me okay?
I'm not interested in your question. I'm not interested in your question. I do not consent.
I messed up here because I shouldn't have never responded. I should have never responded because they said the name and I responded to it. I should not have responded to it.
Mr. Ronald, he can hear you. Just go ahead and ask your question. It'll be up to Mr. Quintero whether or not he's going to respond. Mr. Quintero, I'm directing you to respond, and I'm also just advising you that by not responding, the court will consider a negative inference in connection with any non-responses, okay? All right. Mr. Ronald, go ahead.
Thank you, Judge. Mr. Quintero, we have that your reported earnings for 2018 were $6,585.42. Do you agree with that?
I don't know who you are. I'm not interested. I appreciate your questions, but I'm just here so this matter could be dismissed with prejudice, or you can write an order I can appeal.
And just for the record, David Ronald, Assistant Attorney General. And sir,
I should never have acknowledged him. I didn't fuck up badly here, but just they're non-existent, basically. Like, can you hear a ghost? They're non-existent, right?
you would agree you made no payments for child support in 2018?
Again, I appreciate your question, but I'm not interested. I do not consent. I'm just here so this matter could be dismissed with prejudice, or you can write an order I can appeal.
And then, Mr. Quintero, it looks like we have reported earnings for 2019 of $13,782. Is that correct?
Again, I appreciate your questions, but I'm not interested and I do not consent.
And Mr. Quintero, isn't it true that you did not make any child support payments in 2019?
I appreciate your questions, but I'm not interested and I do not consent.
And isn't it true in 2020 that you are receiving unemployment payments? Is that correct?
Sir, I don't know what's going on. I'm not interested and I do not consent.
Thank you. No further questions, Judge.
Stayed in my square. All right? Fuck them.
All right, thanks, Mr. Ronald. Ms. Hadley, do you have anything that you wanted to add at this time, or do you have any questions?
Yeah, sure. I'd like to add a couple things. I have emailed Exhibit A and Exhibit C that I'd like put on the record. Exhibit A is I downloaded the payment record from the DCSS website. Which
Our clerk's shaking his head that he doesn't have any exhibits. Did you provide those to the clerk of the court?
I emailed them as instructed in the notice to JRUHBERG.
What a dumbass. Emailing stuff is no. You got to physically file your paperwork. All right. It's cute that they do these emails and things like that. She didn't know any better. Doesn't matter. I could care less about what she did.
CPMA.gov.
One second, I'll see if I have them on an email. But have you disclosed those to Mr. Quintero? And
I emailed them on the Yes, sir, I did.
okay. One second, ma'am. So, first of all, do you have any questions for Mr. Quintero?
Do I?
Yes or no?
No, I don't.
Okay.
I don't ask him questions, sir.
And let me just make sure, Mr. Ronald, you don't have any other questions for Mr. Quintero?
No, Judge, and I would just note for the record, the state did file the arrears calculation. Looks like November 6, 2020.
All right, thank you. Do you have any questions at all for Ms. Hadley?
Yes, Judge.
Okay, go ahead.
Ms. Hadley, you had indicated that you were seeking enforcement in this matter because Mr. Quintero has not been making consistent payments, correct?
When I originally ordered this, and I called your office to make sure too, Mr. Quintero had made it clear to the DCSS case manager that I had spoken with. He made it clear to me, and he had not at the time. This was originally filed with other concerns I had of his behavior in March, and he had made at that time no voluntary payments at all. And to this date, he has made no voluntary payments and has made it clear that he has no intention of ever making any payments in this case. All of the things that have been brought in to the COVID and they've been seized.
Hadley, listen to the question. I'm gonna give both you and Mr. Quintero an opportunity to be heard further, okay? But I just want you to answer the questions right now that Mr. Ronald's trying to ask you, Okay?
You've heard the state was questioning Mr. Quintero about different years where he's earned some income. Do you know anything about his job history?
You won't disclose anything to me, so no, I don't know. I just know he wasn't paying.
And then there was the state prepared an arrears calculation based on the payments and the amounts owed. Did you review that?
I did get it, yeah.
Okay. Do you agree with the numbers that were in that report that the state?
None of this matters. None of this matters.
I mean, it does appear to be in line with what's on your website as well, I would assume. So.
Okay. So you don't disagree with the amount?
I don't dispute. No, I don't dispute that. Yes, sorry, no.
Okay. No further questions. Thank you.
Yeah, he knows this is a waste of time. None of this
So,
matters.
Ms. Hadley, was there anything that you wanted to add at this time? Go ahead, ma'am.
Yes, Your Honor, I want to add a few things. This case originally was not established as a what is it called, an IVD case or whatever it wasn't established to
4D.
Okay, the 4D, it wasn't established in that manner, and Mr. Quintero had adequate years of disputing and litigating
None
it.
of this matters. None of this
I
matters.
previously had a lawyer who, Mr. Quintero had tried to get this dismissed several times, I'm sure every party's aware. And it's been denied several times based on that he brought this whole matter, he is the petitioner, he's not the respondent. He brought this whole matter to the court system for them to decide on these matters. And he's just not in agreement with what the courts have decided. So I first want to say that originally this did not originate as
She said originally. It did not originally.
and he did pay when it wasn't a 40 case, and he had no intentions of paying after it was. It's just that the DCSS has been able to intercept the money that the government has given out for the COVID.
Sorry to put you guys through this.
And those are the payments that they've been intercepting now, but he's never voluntarily paid anything on his child support order.
Thank you, ma'am.
Sure.
Yeah, there's no reason for me to say anything. This has nothing to do with me, right? It has nothing to do with me. So, talk. Why am I rebutting? What do I need to rebut? It has nothing to do with me.
And Mr. Quintero, is there anything else that you want to say on your own behalf?
I am present by special appearance in propria persona. I do not understand what's going on, and I'm not interested. I do not consent, and you can dismiss this matter with prejudice or write your order so I can appeal.
There you go.
And sir, did you know that you had a child support obligation back in 2017?
Trying to trick me into jurisdiction.
I appreciate your question, but I'm only here so you could dismiss this matter with prejudice, or you could write an order so I can appeal.
Are you aware, though, that you had a child support obligation that was entered where you were the obligor in that case, in that order?
Again, I appreciate your question. I'm just not interested, and I do not consent. You can write your order to dismiss or an order I can appeal. Make sure it has a seal with a wet ink pen.
He's going to ask one more time to try to trick me. I think. I don't remember, but it's usually rule of 3. They don't know what the fuck to do. Listen to them. Hear that silence? They don't know what the fuck to do.
Is there anything else that you want to say to the court?
You have no jurisdiction over me. I do not consent. You have to prove jurisdiction on the record. And you can either dismiss this matter with prejudice or write an order I can appeal.
There you go. There you go.
All right, thank you, sir.
Yeah, you're welcome.
Mr. Ronald, was there not a child support order entered on July 31st, 2017?
Judge, in this case, there was an order entered, and the order was entered on July 31st, 2017, with an order that would be effective August 1st, 2017, of $317 a month.
Doesn't matter what he says. Statements of counsel and brief and oral arguments are insufficient for summary judgment. Trinsley versus Pagliaro. Doesn't matter what he says. That guy didn't testify and he didn't swear under oath. He is hearsay. Hearsay. Only hearsay.
In this case number, correct?
Yes, Judge, in this case number.
Okay. And sir, did you file motion for reconsider or decision overturn?
There it is. The third
Looks
question.
like August
Try it
4th,
again.
2017 in connection with that order?
Jurisdiction. He's trying to get me. There it is. I knew there would be a third. There it is.
Mr. Quintero, did you hear the court?
I'm sorry, what?
The court. He is not a court. He is a man outside of his jurisdiction right now, trying to tell me what to do, trying to ask me questions. There's no jurisdiction on the record. He's not the court. A judge is not the court. That is impossible. Okay? He only claims he is as soon as I give him jurisdiction. He's just a man.
Mr. Quintero, didn't you file a motion for reconsider? I'm stating it the way you've written it. Motion for reconsider or decision overturn. It was filed August 4th, 2017.
You know what? I appreciate your question. I appreciate your question, but I'm only here so you could just dismiss this matter with prejudice or write an order I can appeal.
There you go, baby. Three
Do you
questions.
dispute that you signed said pleading August 4th, 2017?
I'm not
Went
interested in the question. I do not consent.
He's going to go again, I think.
Understood. Thank you.
Oh, no. All right. 4 times he tried to trick me.
Let me just ask any of the parties, beginning with Mr. Ronald. Mr. Ronald, do you have any other questions, or are you familiar with the exhibits A and C that were submitted to you and Mr. Quintero?
That's by Ms. Hadley.
Yes.
Judge, when were those sent over to the state? What date?
I don't know. Ms. Hadley, can you clarify? First of all, the clerk doesn't have those exhibits. So I'm not inclined to admit any exhibits that haven't been provided to the clerk. There's a drop box, I believe, on the. I'll get some clarification from our assigned clerk, Frank. Is there a drop box?
Sorry, this is so long.
Second floor. So any exhibits have to be submitted to the clerk of the court. They have an area on the second floor of the Superior Court building where those can be provided, okay, so that legal records can receive them and have them prepared for purposes of the proceedings. That hasn't happened today, okay?
Okay, Your Honor. I was just following the notice of orders, like what it told me to do in there. So that's fine.
Okay.
Sorry. It's not crucial.
All right.
Following instructions on a notice, it's not an order. None of this shit is real. Right? She was following instructions on a notice. It's a contract offer, is what it is.
So with that, is there anything else that any party would like to present in the way of any evidence. Mr. Ronald?
Judge, just to avow to the court that Mr. Quintero, his reported earnings for 2018 for the year was $6,585.42. For 2019, $13,782. And for 2020, $7,074.08. And just that the first, there wasn't a payment made in this case till 2020. When the order was in 2017.
Thank you. Ms. Hadley, do you have anything additional?
No, I mean, I don't have anything additional without this, so, no. Because Mr. Quintero works for cash, he's an entrepreneur.
Mr. Quintero, do you have anything additional at this time?
I'm present by special appearance in propria persona. I do not understand what's going on. I just need an order so I can appeal, or you can just dismiss this matter with prejudice. That's all I'm here for.
Thank you.
I was a little nervous because this was my first time. I had no idea, how this was going to go. I'd never been through this. But as you see the other videos, I speak with a lot more confidence, and, there's like no mistakes.
That wasn't additional, but thank you. Mr. Ronald, do you have any recommendations?
Yes, Judge, the state would recommend that Mr. Quintero be found in contempt, and that a judgment be ordered based on the arrears calculation dated November 2nd, 2020, that was filed in this case. It was the principal and interest amount that those be ordered. This judgment.
All right, thank you. Ms. Hadley, do you disagree with any of those recommendations?
No, sir, I don't disagree with anything. I just want to keep getting this enforced because it is a parental obligation to financially support our children.
All right, thanks.
Thank you.
Mr. Quintero, do you have anything additional, any disagreements with those recommendations?
I don't know what's going on here. I don't understand. You don't have jurisdiction over me. Jurisdiction was not proven, and I have no interest in this matter. You can dismiss this with prejudice or write your order so I can appeal.
All right, thank you, sir. The court does find that it has continuing jurisdiction in this matter, both with respect to the subject matter as well as the parties involved. The court.
Liar, 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 liar. They are allowed to lie. Did that fake judge swear under oath at the beginning? Did the prosecutor swear under oath at the beginning? They are lying. Doesn't matter what they say.
Does further find that there is a current child support obligation. It's a valid order. The court further finds, and the court does take judicial notice of the file, and specifically the motion for reconsider or decision overturn filed August 4th, 2017 by David Quintero in connection with that child support order. The court finds that Mr. Quintero does in fact child support order. And specifically, that's the order that was entered July 31st, 2017. The court does find that Mr. Quintero is non-compliant with said child support order.
There's no
The
order.
court finds
There's no case.
that Mr. Quintero has never made a voluntary payment in connection with that child support order, and despite having sufficient income to at least make good faith payments in both 2018 and 2019, that he failed to make any child support payments. The court does find that he's currently unemployed. He's receiving unemployment insurance benefits, and some of those benefits are being applied to his support obligation.
Which is, by the way, illegal, actually. Unlawfully.
The court does find that his noncompliance was willful. The court does find him in contempt of court for failure to pay child support as court ordered. The court, as a purge, the court just orders that Mr. Quintero report to the Division of Child Support Services any employment that he obtains between now and the review hearing that the court will be setting.
Nah, I don't think so.
And let me just ask you, Mr. Quintero,
Tries once
I
again.
suspect you're not going to answer the question because of the way you've responded to all other questions, but presumably in order to receive those benefits,
Presumably.
are you in the process of looking for work?
I appreciate your question, sir. I'm just here so you can either dismiss this matter with prejudice, write an order, I can appeal. You have no jurisdiction over me. Let's all just write an order with a sink and a wet ink pen so I can appeal. I have no interest in any of
With a stamp, not a sink. I fucked up.
these questions. For the record, I do not understand what's going on. I have no idea what's going on here, and I do not consent.
Good job. Good job, buddy.
Yeah, I'm going to order, thank you, sir. So the purge is as follows, and this is so that Mr. Quintero can purge his contempt that's been found today in connection with these proceedings, to report any employment that he should obtain between now and the review hearing within 2 weeks of obtaining new employment, that he report that to the Division of Child Support Services. The court will further order that Mr. Quintero apply for a minimum of 3 jobs per week, beginning this week, between now and the review hearing.
He's making a contract offer right now. That's what he's doing.
The court will further order that Mr. Quintero report to one of 2 agencies, either Arizona at Work or Pima County One Stop. In order to obtain services in connection with his desire to find find a job at this time, his need to find a job at this time. So let me just ask you, and
Again, he's
I
going to try.
suspect that there will be a similar response as you've already stated, as to all questions that have been asked today. But do you have any source of income other than your unemployment insurance benefits?
I appreciate your question. Just here so you could dismiss this matter with prejudice or write an order I can appeal. Thank you.
There you go. He tried
Thank you,
7
sir.
times. I think that was the number. 7 times? Tried to trick me into jurisdiction?
And let me just ask, Mr. Ronald, anything else that you're asking the court to consider as the purge of his contempt?
No, Judge, I think the court covered it.
All right. And I'm going to set a review hearing, so if everybody will please look at your calendar, I'll set a review hearing in this matter.
Review hearing, huh? I thought there was contempt.
Judge, it's going to be a signed main entry with the principal and interest amount as a judgment, or how is the court going to do that?
I'd ask that the state submit a form of judgment.
Okay.
And then the court will review it and consider consider its findings and orders today. And if it's consistent with the court's findings and orders, it'll go ahead and sign that, and it'll be filed.
I thought there was contempt, huh?
All right.
But they're having hearings? He wants to have a review hearing?
I'm looking at the date of March 31st. It's a Wednesday.
Sounds like a whole lot of smoke to me.
11 a.m. that day for 30 minutes.
That's good, Judge.
Mr. Quintero?
I should never respond to him when he says the name.
Mr. Quintero, did you hear the date and time for the review hearing?
Is that a question?
Yes.
Oh, I appreciate your question, but I'm only here so you can either dismiss this matter with prejudice or write an order I can appeal.
There you go. There you go.
Okay, this order setting the matter for review hearing, March 31st. This coming year, 2021. That's at 11 a.m. And let's just have the record reflect that the court is not ordering as part of a purge any additional payments other than what's being withheld from the unemployment insurance benefits. The court does, however, admonish Mr. Quintero that he is court ordered to pay current support obligation of $317 per month. The failure to do so could result in additional sanctions, including but not limited to incarceration. The court further admonishes Mr. Quintero that
Additional sanctions. I've gotten 0 sanctions so far. All they do is they don't make good on any of their threats. I've gotten 0 sanctions.
to appear at any future hearing. Without good cause may result in the court making a finding of contempt for failure to appear, and a child support arrest warrant.
A child support arrest warrant. That's a capias or a capias or however you It's basically a bench warrant, right? Whatever, you know. All right, make your threats. Okay.
issue. The court does not find today that Mr. Quintero has the ability to pay any more than what is currently being withheld from his unemployment.
Court finds that, what do you say, Mr. Quintero does have the ability to pay? The ability to pay. Where are they going to get that evidence from? If you incriminate yourself is where they'll get it from. But if you don't provide the evidence they need, then they can't continue. There's no finding of fact.
Insurance benefits, and the purge is, again, that he report any employment that he obtained between now and the review hearing within 2 weeks of obtaining that employment to the Division of Child Support Services case manager, that he applied for a minimum of 3 jobs per week between now and the review hearing. That's beginning on today's date. And that he report to either Arizona at Work or the Pima County One Stop to obtain any additional guidance or services in connection with his job search. The court's already set the review hearing. Again, the date and time of the review hearing is March 31st, 2021 at 11 a.m. And call-in information will be provided between now and the review hearing. I don't think there's anything else that we can do in this matter today. Ms. Hadley, do you have anything additional, ma'am?
No, thank you.
All right. Mr. Quintero, anything additional? And you don't have to repeat what you've already said. Do you have anything additional, yes or no?
You have no jurisdiction over me. I have witnesses that witnessed jurisdiction not being established. I order this matter dismissed with prejudice.
That request, I'll consider that as a oral motion for reconsideration of the court's ruling already with respect to Mr. Quintero's motion to dismiss for lack of subject matter
practice
jurisdiction
from the bench
today. Earlier, that ruling is in writing. It was filed on today's date. The court's construing his statement as
Construing.
for reconsideration of said
Practicing from the bench is what you're doing.
Denies his motion for reconsideration. And let me hear from Mr. Ronald. Mr. Ronald, anything additional?
Fucking crooks.
So in the order that the state prepares, I'm going to leave the payment of arrears at blank at this time. Put 0 or what does the court prefer?
Well, yes, I'm not entering a payment on arrears today. I don't know that there's been one entered. If the existing child support order, which as I've already found is a valid order, entered as I already stated, and
All right, he knows that that the state, they're not a party, they're not a witness, they're not anything, right? And he's not under oath, so therefore he can't submit evidence. So he was trying to commit even further fraud there, trying to add the arrearages and all this other shit and whatever it was. Let me see if I could go back real quick.
if the existing child support order appears today, the
order that the state prepares, I'm going to leave the payment of arrears at blank at this time. Put 0 or what does the court prefer?
well, yes, I'm not entering a payment on arrears today. I don't know that there's been one entered. If the existing child support order, which as I've already found is a valid order,
Okay, yeah.
entered as I already stated.
He wanted to tell him to
I don't see an
to come up with arrears.
So, and the court's further not ordering entry of judgment on arrears. So the court reserves
Because there's no finding of fact.
entering any judgment on arrears at this time. The court reserves entering a payment on arrears.
They would have to prove ability to pay.
Administrative one that I'm seeing of 10461.
And administratively, that could occur. And okay, I know Mr. Quintero's not going to give the court enough information for the court to consider a payment on arrears. And based on my findings today, I'm not.
Did you hear that? Okay, so because he basically said, well, he's not going to incriminate himself, so I have no finding of fact.
Fine to enter a payment on arrears, but of course, whatever the state, as a matter of law, will be doing administratively may adversely affect Mr. Quintero, but that's something that he can take up on administrative review if he believes the state has incorrectly utilized its administrative remedies. So that's something Mr. Quintero can address administratively if necessary, and that's something that's going to be reserved at this time. There's nothing else that the court's going to find. Thank you. So there's nothing else that the court is going to do to address the pending matter today. Any additional matters will be addressed at the time of the review hearing. That's on March 31st of this coming year at 11 a.m. That's for 30 minutes before the court. And we're adjourned, folks. Feel free to hang up at this time. Thank you.
Thank you.
Thank you.
And fuck off.
You never got it. Never got it.
That's right. I knew it. I knew it right then and there. He never got jurisdiction. I knew it at that time. So, first of all, I did file my special appearance before. I did file a motion to dismiss. I demanded a de novo review. I demanded a bill of particulars. I had to stand out on my paperwork. All of this had to be filed first. It has to be filed first, right? And then you stand on it at court, right? And then, also in the paperwork was not just a demand for de novo review, but also for a Turner versus Rogers hearing, which is basically an indigency. I don't know, I'm not saying it right. Hearing, basically, they have to prove ability to pay, right? Trial by jury, all of that, anyways. So it was all in the paperwork. I let my paperwork do the talking for me on the record, and I had no need or reason to speak here. So that was just the first phase of the contempt hearings, all right? I have the other two videos that I did for the March 31st hearing and then the June 3rd hearing. I'm also going to do explanations on those hearings. I was coached by Chris Henry from Child Support Made Simple. Check out his videos. He coached me, helped me out with my paperwork. I too now have been making calls and putting in my own work and helping other people. So please help me in my journey as well, because this takes my time as well, and I'm doing this for you guys, because it's not right what they're doing. It's not right what they're doing. So this is for informational purposes only and educational purposes only. I am not liable for whatever it is that you guys do in your court. I'm only showing you what was done here, and how I deal with these situations. So hook me up, please help me out, so that way I can continue to spend time and continue to do this and put these videos up for y'all. The Cash App info and all that is in the hold on a second. The Cash App and the PayPal is all there if you want to donate to help me out, please. It's in the videos. Anyways, thank y'all, and much love to Rio 4D Help Child Support Termination Group, Child Support Scheme Group. These groups that have a lot of information. And check out Child Support Made Simple by Chris. All right, see y'all.